We've been looking at, over the past few months, with various different guests, the difference between what is lawful and what is legal, and how the legal system affects us greatly, and whether we're in the private or in the public. And when we say public, we actually often really mean a private system that's pretending to be public, such as court buildings. You know, we think of the court buildings as being public buildings, when really and truly they are private buildings run by the Bar Guild. And we're going to explore this with the 12 presumptions of law. And I thought it would be interesting to have a look at this, because the law, or the legal system, I should say, which is ages old, goes back to the Vatican, and is actually run by the Bar Guild. But this is canon law that is, as I say, centuries old. And it's a system that's there in many ways to trick you, because they have these presumptions. And unless you know that they're taking these presumptions and you rebut them, you are really being taken advantage of. They're tricking you. They're getting a jurisdiction over you that perhaps they really oughtn't. So let's have a look at the 12 presumptions of law. I think you'll find this really fascinating. So here we go, the 12 presumptions of law. You can look this up, by the way, on the internet. There are many places that show these. Some have slightly different interpretations, but they are in pretty much the same. It is canon law, as I say. So let's have a look and see what it actually means. So this is going to be a slightly longer video than my normal monologue, but I think you'll find this quite fascinating. So here we go. Canon law 3228, and away we go. A Roman court does not operate according to any rule, any true rule of law, but by presumptions of law. Therefore, it presumes Therefore, if presumptions presented by the private Bar Guild are not rebutted, they become fact and are therefore said to stand true, or as truth in commerce. And everything done in the legal system is done with commerce. You're dealing with these dead corporations that don't exist. They only exist on paper, in the computers. They need employees, to real living men and women like you and I, who are living men and women. They need people to actually make them work, because they can't do anything in and of themselves. So it's a fascinating thing. So, and that's what they call commerce. Right, let's carry on. There are 12 key presumptions asserted by the private bar guilds, which, if are unchallenged, stand true, being public record, public service, public oath, immunity, summons, custody, court of guardians, court of trustees, government as executor stroke beneficiary, executor de son tort, incompetence and guilt. They are the 12 presumptions, and we're going to look at those one by one. And you should know that, you know, private bar guild, they'll be the ones, the barrister, the judge, the prosecutor, all running them in the courts. They're all run by the private bar guild, and we'll find out more about what they are as we go on with this. So let us have a look at the first one. And number one, the presumption of public record is that any matter brought before a lower Roman court, such as a magistrate's court, is a matter for the public record, when in fact it is presumed by the members of the private bar guild that the matter is a private bar guild business matter, unless openly rebuked and rejected by stating clearly the matter is to be on the public record. The matter remains a private bar guild matter, completely under private bar guild rules. So in other words, there you think that you're going into a public court that is on the public record, but it's not. It's presumed by the bar guild that unless you actually state that, It is you're going into a private meeting, which doesn't have to be recorded and is private and for their eyes only. Only they don't tell you that, you see. So you have to go in and rebut this and say to them that this is, I rebut that this is a private matter. This is for the public matter. I want it on public record, because they'll presume, unless you do, that it is a private matter. Right, let's go on to the second one. And the second one here is the presumption of public service. So this is that all the members of the private bar guild who have all sworn a solemn, secret, absolute oath to their guild then act as public agents of the government or public officials by making additional oaths of public office that openly and deliberately contradict their private superior oaths to their own guild. So again, unless openly rebuked and rejected, the claim stands that these private bar guild members are legitimate public servants and therefore trustees under the public oath. So again, you go in thinking that these people are actually public servants doing it, but the presumption that they hold is that's what you think, but they're not. So again, you have to rebut that and expose them for who they are, that they are running a court under private guild and their own oath, their private bar guild under their own oath, and that their oath is superior to the public one. So again, you've got to be extremely wary about it. Just understanding this will give you a completely different idea of how the courts work and how they are all the time trying to get jurisdiction over you. But you can rebut all of this and state who you are. So you have to know who you are. Let's have a look at the next one. And all of this will slowly become clear how you're being tricked in the courts. So the third one is the presumption of public oath. And this is that all members of the private bar guild, acting in the capacity of public officials, have sworn a solemn public oath and remain bound by that oath and therefore bound to serve honestly, impartially, and fairly as dictated by their oath. And again, unless openly challenged and demanded, the presumption stands that the private bar guild members have functioned under the public oath in contradiction of their guild oath. And if challenged, such individuals must recuse themselves as having a conflict of interest and cannot possibly stand under a public oath. So this again, this is where you've got to rebut the fact that they're actually under a private oath. You think that they're doing a public oath because you don't realise. The presumption is that that's how you're going to take it, but that they are actually under their own oath. And so you call them up on it because they cannot have a private oath, which is superior to their guild, and a public oath because that's a conflict of interest. You have controversy. And so if you pull that up and you let them know, of course they have to recuse themselves, which means basically they run out of court. They cannot run the court if you then say, well, hold on a second, there's two oaths here. Who are you actually serving? Are you serving yourselves, which they are, and you're just pretending that you're serving the public? So again, being aware of all of this changes how you think about and how you worry about if you have to go to court. So just keep this in mind. Let's go to the fourth one then and see where that takes us. This is the presumption of immunity. So this is that key members of the private bar guild, in capacity of public officials acting as judges, prosecutors and magistrates, who have sworn a solemn public oath in good faith, are immune from personal claims of injury and liability. But they're not really immune to any of this. So unless openly challenged and their oath demanded, the presumption will stand, of course, that the members of the the private bar guild as public trustees who are acting as judges, prosecutors and magistrates are immune from any personal accountability for their actions, which of course, so that will stand unless you call out and say, well, hold on a minute, you are liable and you're personally liable. So again, you have to rebuke or rebut or reject these presumptions that they automatically have presumed. And you don't know that these are the situations. Let's move on to the fifth one. And I urge you really to have a look at these and take time to, I'll leave a link to this one, but that you can go searching on the internet and you'll see them all over the place. And just take time to understand what's going on here and what it really means. So number 5, the presumption of summons. Now, this is really interesting. I find this one fascinating. This is the presumption that it is that by custom a summons, unrebutted, stands, and therefore one who attends court is presumed to accept a position, such as a defendant or a jury or a witness, and jurisdiction of the court. So in other words, attendance to the court is usually an invitation by summons. Now that's interesting because we think of summons, don't we, as this, oh my goodness, I've been summoned to the court. We summon the dead, don't we? We summon them. It's like some ritual, which effectively being canon law. This is, of course, goes right back to the Vatican and all of this nonsense. But it's really just an invitation. You are invited to come to court. You don't actually have to go, but you have to rebut this. Let's see how that works. So unless the summons is rejected and returned with a copy of the rejection filed prior to choosing to visit or attend jurisdiction and position as the accused and the existence of guilt stands. So in other words, if you get your summons, it comes in the post and you think, oh blimey, what am I going to do? I've got to go to court. But you reject this, you rebut it, because it's a presumption that if you turn up at court, that you are going to be guilty, that you are accepting jurisdiction, that they will put you in the position of trustee, that you'll have to attend. So again, it's a presumption that they will assume this unless you rebut it. So you can see the power is shifting. If you know how to operate this, the power is shifting from them having all the control because of their presumptions. And if you don't know that, then, if you are innocent of this knowledge, that does not help you. I forget what the maxim is. It's something like not knowing the law is no excuse. Somebody, I'm sure, will put the correct one in the comments. Let's have a look at the next one, which is the presumption of custody. And so this is that by custom, a summons or warrant for the arrest, unrebutted, therefore stands, and one who attends the court is presumed to be a thing. We'll get onto that in a minute, and therefore liable to be detained in custody by custodians. Let's just raise that up a bit. So this includes the dead legal fiction, the non-human person. That's the name, the name in capital letters, the legal fiction when you get your name and it's all in capitalization. It's not obviously you. It is legalese, dog Latin if you like. It is just a reference to you, but it's not you at all because you're a living man or a living woman. This is the legal fiction. We've spoken about this before, set up based on your birth certificate and things like that. We'll go into this again in more detail so we make that clearer. But so this is the presumption that you are effectively a thing rather than a real living man or woman. Let's find out how that works. So let's just go back to the top of that. This includes the dead legal fiction, non-human person that corporate government rules and regulations are written for. So they're just written for this legal fiction, not for you as a living man or woman. Custodians, unless, of course, you allow them the jurisdiction. That's the difference. Custodians may only lawfully hold custody of property and things, not flesh and blood, possessing beings. So unless this presumption is openly challenged by rejection of summons and or at court, when you're there, the presumption will stand that you are a thing and property, and therefore lawfully able to be kept in custody by custodians. So again, you're not a thing, but they'll presume that you are a thing, that you are something that's been brought from a ship into a cargo. You're an object, but you're not. And so this is why you have to, again, rebut this. Let's move on. We're getting through. I said it was a bit involved and complicated, but I'm sure you're finding this absolutely fascinating. The presumption of court of guardians. Interesting title, that. This is the presumption that you may be listed as a resident, which again is a legalese word. You think of resident, oh yes, because you live in a house, you are a resident. This is legalese terms and want to be avoided at all costs for a living man or woman. A resident of a ward. And again, in the government area, in your area, you talk of, oh, this is a ward and this is a ward. Think of a ward like at an orphanage, where you have no parents, or rather you have no mother or father, and you're in a ward, or in a hospital in a ward, and you are somebody who is young and have no... you're not over the age of majority. You're being looked after by the state, if you like, in a ward, or looked after by doctors and nurses. There's somebody's authority is over you. That's what we're talking about when we get to ward. So let's just have another look at this. So this is the presumption that you may be listed as a resident of a ward of a local government area and have been listed on your passport with the letter P. If you look at your passport, chances are, unless you've actually done something about this, you will see that up on the passport, in a tiny little area, there is the letter P. It means you're a pauper. And unless, again, you rebut this, you remain a pauper. You are a pauper. Here it is. You are a pauper, and therefore under the guardian powers of the government and its agents as court of guardians. So unless this presumption is openly challenged, to demonstrate you are both a general guardian and general executor of the matter, the trust, before the court, the presumption stands, and you are by default a pauper and a lunatic, and therefore you must obey the rules of the clerk of the guardians, which of course is the clerk of the magistrate's court. This is something that can take a bit of, mind control. They're basically assuming that you are a thick imbecile, a lunatic. You're not of your own right mind. You're not of your own living man or woman. They can't deal with living men and women. So, again, you have to say, I am not under your guardianship. Thank you very much. I am my own general guardian, and I am the executor, and we're coming on to this term which will be used quite a bit now, the executor of the trust. And you may think, what are you talking about? Where is the trust? But there is a trust, and in court and in legal things, this trust, all the time they're trying to get the jurisdiction to make you the trustee, because in the trust there's three positions. There's the executor, there's the beneficiary, and then there's the trustee. And the trustee is the one that is liable for the costs and for doing things, or for having punishment done to them in the court. You don't want to be the trustee, and actually you're not the trustee, unless of course you allow the presumptions to continue. So again, you have to rebut. Let's have a look and see what that looks like then on number 8. So the presumption of Court of Trustees is that members of the private bar guild presume you accept the office of trustee as a public servant, and government employee, just by attending a Roman court, as such courts are always for public trustees by the rules of the guild and the Roman system. So the magistrates' court is a Roman court, and you are deemed to be the trustee. You are employee. That's how they will look at you, unless, of course, you rebut it, which is what we're going to do. So unless this presumption is openly challenged, to state that you are merely visiting by invitation. Remember the summons? It's only an invitation, and you're only there to clear up the matter, and that you're not a government employee or a public trustee in this instance. And if you don't rebut that, the presumption stands, and it is assumed as one of the most significant reasons to claim jurisdiction, simply because you appeared. So it's very important that you do get rid of that, because you don't want to be the trustee. And most people, of course, do end up being the trustee, which is why they're liable. But we're going to turn that round. So number 9, the presumption of government acting in two roles. Now this is where we get back to the executor. So the presumption will be of government acting in two roles as executor and beneficiary. So this is that for the matter in hand, the private bar guild appoint the judge and magistrate in the capacity of executor, while the prosecutor acts in the capacity of beneficiary of the trust of the current matter. You don't want them to be in charge. So unless this presumption is openly challenged, to demonstrate that you are both the general guardian and general executor of the matter, i.e. the trust, before the court, if you don't reject this, the presumption stands that you are by default a trustee, and therefore must obey the rules of the executor, the judge and magistrate. Well, we're going to turn that round, because you're not going to be the trustee, because that's why you have to obey everything. It is a very simple system once you've got your head around it, that you understand that they're making these presumptions. It is a way that they trick you. So you're going to turn around and say, well, actually, do you know what? I am the executor. I'm very sorry. And the beneficiary. You may well be the sole beneficiary of whatever it is in court. And you may not even need to get to court, because when that summons comes, you're going to reject all of these things, rebut them all, and say, well, actually, do you know what? I am the executor of this. I'm the one that tells you what to do, and I am the sole beneficiary of this, and you're the trustee. And as the trustee, you can pay it. You can pay the debt. You can go to the trust and take the money out and stop bothering me, is effectively what's going on. So let's have a look at number 10. We're nearly at the end. We've got 2 more to go. These are quite tricky to get your head around, but let's have a look. The presumption of executor de son tort. Okay, so that's an interesting terminology. It's I think that must be French. Executor de son tort is the presumption that if the accused does seek to assert their right as executor and beneficiary, which is what you want to do, over their body, mind and soul, that they are acting as executor de son tort. In other words, a false executor. Now, let's just pause there for a moment, because the moment that you say, okay, I'm not the trustee, I am the executor and sole beneficiary, the assumption will be that you are now acting as executor de son tort. In other words, a false executor. So they're already trying to trap you yet again if you try to claim the executorship of it. However, you're going to rebut that is the presumption. You're going to rebut that you're not an executor de son tort. So again, you're batting away all the things they throw at you. So let's just see how this works. So here we go. If the accused does seek to assert the presumption, is, of course, that the right as executor and beneficiary over the body and mind and soul, that you are now acting as a executor dissent or false executor, challenging the rightful judge. The rightful judge is sitting there with his wig and gown, who is the executor. However, so therefore, the judge and magistrate assumes the role. He assumes the role of true executor and has the right to have you arrested, detained, fined, or forced into psychiatric evaluation. Now, this happened to a friend of mine called Stuart, and he was held in psychiatric evaluation. So again, unless this presumption, and you have to do this bloody quick before they start arresting you, is openly challenged by not only asserting one's position as executor, as well as questioning if the judge or the magistrate is seeking to act as executor dissentor, the presumption stands, and a judge or magistrate of the private bar guild therefore will seek assistance from the bailiffs and the sheriffs to assert their false claim. Now, I've not been in court and I've not had this done, so I'm just going by this, but I am advised by my friend Stuart, who has had this happen to him. So again, you accuse, so you bring your standing in right from the beginning, and you say you're the executor and sole beneficiary of the matter, which means that they have to be the trustee. And from this, it seems that they will then presume, oh, actually, you're acting as executor dissentor, a false executor, but you rebut that immediately and say, well, no, actually, you are acting as the, which is what they are. They're acting as the executor of the trust dissentor, a false executor. So you rebut that, so you keep your standing. You've got to, so then they can't arrest you. Right. We're coming to the end of these 12 presumptions. I may just have to move them down a little bit so we get to see them a bit more clearly. Let's get here. Here we go. So number 11, the presumption of incompetence is the presumption that you are at least ignorant of the law and therefore incompetent to present yourself and argue properly. Therefore, the judge, magistrate, whatever, as executor, because remember they're presuming to be the executor, but actually they're executor dissentor, a false one, has the right to have you arrested, detained, fined, or forced into psychiatric evaluation, as we just saw. So again, unless this presumption is openly challenged to the fact that you know your position as executor, as I said just now, and beneficiary, and actively rebuke and object to any contrary presumptions, then of course it will stand by the time of pleading that you are incompetent. And then of course the judge or the magistrate can do what they need to keep you obedient, which may well be arresting you. So again, you rebuke all of this. And finally, number 12, the presumption of guilt. This is the presumption that as it is presumed to be, as we said at the beginning, a private business matter of the bar guild, not public, because if you haven't rebutted this, they're going to think of it as a private bar guild matter. They will presume that you are guilty, whether you plead guilty or whether you don't, whether or not you plead guilty. Do not plead or plead guilty. Therefore, unless you either have previously prepared an affidavit of truth and motion to dismiss with extreme prejudice on the public record, or call for a demurrer, then the presumption is that you are guilty, and the private bar guild can hold you until a bond is prepared to guarantee the amount the guild wants to profit from you. So in other words, unless you rebut this, that the presumption of guilt is not, and you rebut that this is a public, not a private matter, but for public record, then they can't treat it as a public, as a private matter. You can see how easily complicated this gets. And so therefore, if you don't, of course, then they can decide how much they want to fine you, effectively, the bond that they're talking about, and how much profit. The courts are corporations. They are there to make a profit from you. They're businesses. And so it goes with these 12 presumptions. And so you need to bat these away and rebut them right at the start. And you may not even need to go to court at all, because you can do that in your paperwork as soon as these bills come in, whether it be a parking bill, a speeding bill, a not paying the council tax bill, whatever it is. When you go to court, this is how they're tricking you. These presumptions, as I say, are online. You can look them up. Spend time looking at them, because you can, and it takes a bit of getting your head around, as I've said repeatedly, take away these presumptions. Obviously, if you're guilty of a real crime, then you don't want to be in a magistrate's court anyway. You want a trial by jury, by your peers. Not a jury trial, which is something very different, but a trial by jury. But we'll talk about that in future ones. I hope that's been of interest, and I'm going to be looking at some more of these sort of things where we have more control as sovereign people and move away from this corporate Britain. Thanks for watching.